Learn how Hartford's failure to allow a policyholder to respond to unfavorable neurological reports to further bolster its claim shocks a Second Circuit judge. Did you know that the new ERISA regulations give the policyholder the last say in rebutting any new evidence that a carrier will develop when the carrier reviews an appeal of a denied claim? My appeal letters are 25 to 65 pages long, written by me, and I attack every reason for the claims denial. The ERISA regulations now say that if the carrier gets new or updated opinions to uphold the claims denial, that the carrier can't just cite this evidence in its updated claims denial or hide the report like they used to. Let me give you an example. This is the case of Hughes versus Hartford Life, and it's a Connecticut case. Hartford denied Hughes a full and fair review of her claim when it denied her right to see and respond to the report of Hartford's IME neurologist before it denied her claim a second time. Ultimately, she filed a lawsuit, and the court held that this new neurological report was relevant to her claim, and Hartford had relied on it extensively in its denial letter. The Second Circuit judges were shocked that Hartford failed to follow the rules, and they took Hartford to task in its wrongful claims denial. It's refreshing to see a court do that. Now, the lesson to be learned is that every denied policyholder has the last say and should challenge and rebut any new evidence used by a carrier to uphold the claims denial. That means that if the carrier has had an IME, you may want to go get an IME. You may want your treating physician to comment on the IME. You might want to get a functional capacity evaluation. But it's incumbent upon you to develop the new evidence and rebut whatever the new denial basis is grounded in. In other words, we get the last say. And I think that's great because far too long, disability carriers have read a great appeal letter like mine, come up with a new reason, and said, guess what? You can't respond. Well, the new ERISA regulations prohibit that. If you are being sandbagged by your disability carrier, if they've come up with a new reason to deny your claim and say, too bad, so sad, it's time to call me, an experienced ERISA disability attorney. I can help you get the disability benefits you deserve regardless of where you live in the United States. But you need to know you'll only have 180 days in which to file an appeal. Don't delay. Call today, 727-894-3188.